It was a standalone piece of legislation that the House had introduced 5-6 years ago in an effort to bolster accountability for discrimination issues. They wanted to make sure agencies were handling discrimination issues in a way in which that rooted it out and provided discipline for who engaged in it. That was the original mindset behind the No Fear Act. So when the House Oversight Committee, which was led by Elijah Cummings, started looking at things, they had reached out to various groups of ways to strengthen. And over the years, they introduced this legislation several times. It had passed the House on a couple occasions and stalled in the Senate. And that happened again in 2020, where, there are 432 members of the House, and over 400 members voted in favor of this act. It had got to the Senate and it stayed there for a while, but this summer the Senate decided to move it forward, but moved it, instead of a standalone piece of legislation, made it a part of the National Defense Authorization Act, which is a huge piece of legislation that has so many components to it. So it kind of in some ways is buried within the NDAA, but it is still a viable statute that stands alone, but it was passed through that legislation. That legislation was vetoed by the president for reasons unrelated to the Cummings Act, but the Senate and the House overrode the veto on January the 1st of 2021, and this became law January 1st, 2021. Like I said before, I'm going to go through the portions of the act that really pertain to the things that we do at EEOC, and then we'll open it up for questions. So one of the strengthening elements that it required is that it requires each agency to report reports on findings of discrimination. Once the case has been exhausted, like there are no more appeals or a court has issued a final order, then the agency must post on their public website within 90 days of a finding information about that finding of discrimination, and that finding must remain on their public website for 1 year. An additional requirement is after the final action is taken, so if an administrative judge issues a finding of discrimination and the agency decides to implement it, then that's considered a final action. If EEOC issues a decision and the appeals have been exhausted and there's no further appeals, then that would be a final action. That within 120 days of that final action, the agencies now have to submit a report, a disciplinary action report to EEOC that really lays out whether disciplinary action was proposed against a federal employee for a violation of the law and the reasons for the discipline or not to discipline the employee. Even though we recommend discipline in our orders, we don't have statutory authority to say that you have to discipline an employee. The relief that EEOC provides in our discrimination process is make whole relief to the victim of discrimination. So those are things that make the person whole. It's not necessarily the type of orders to punish. So I always give this analogy to folks. If somebody was outside and there was a person in the crosswalk and they were crossing legally and a car ran the red light and hit that individual and they were injured, there'll usually be two entities that respond to that incident. There's going to be the paramedics. They're going to come in, try to get that person, take them to the hospital, do the things necessary to resuscitate them to help, provide them some relief. That's what EEOC provides. We provide the make whole relief to the victim of discrimination, restoration of leave, back pay, promotion, anything that would have gotten that person's career back. Also, if there's a violation like that, then if there was a hit and run, the police would come in and the police would determine if there had been a criminal wrongdoing and hold that person accountable. EEOC doesn't have that authority to deal with that type of misconduct. It's left to the agencies to deal with misconduct through their misconduct procedures. But it creates this gap where folks will see that there's a finding of discrimination, but the manager who engaged in the discrimination or the employee who engaged in harassment was not disciplined or terminated. And it created a lot of frustration. And so Congress was trying to say, even though we're not giving EEOC authority to fire or take action, agencies need to report to EEOC and Congress to let us know that there was a consideration of discipline and what that was involved. And that's what this new disciplinary action report requires agency to do. In Section 207, it requires agencies to have a complaint tracking system to track issues that's raised in the EEO process from beginning all the way to disciplinary action. Now, most agencies already have tracking systems, even though it wasn't required by law. This really put that requirement squarely as a statutory requirement that you have a complaint tracking system. Some of you use iComplaints or your own embedded system. Some agencies just use spreadsheets. But this is really requiring agencies to have an official electronic system for tracking complaints. The next section that I'll talk about is in line with holding folks accountable, and that's personnel records. So once again, when a complaint has been resolved and there's a finding of discrimination and the appeals have exhausted and there's a finding that the agency had engaged in discrimination through a particular employee, then there has to be a notation in that employee's record that they had engaged in discrimination. Now, this is one of those overlapping areas. I said that, some of this affects EEOC, some of it affects OPM. OPM is going to be the agency that you look to define how this goes into official personnel records because, that is within their purview. But that is something that the Act is also requiring. And in Section 401, it talks about the fair and neutral processing and resolution of complaints. And it goes further that says each agency shall be responsible for the fair and partial processing of complaints. And it really dives into making sure that the EEO program is structurally put in a place where it can do the job of a neutral arbitrator trying to root out discrimination versus being circumvented potentially because of layers of bureaucracy. And so it states that each agency must establish a model EEO program, and that's very similar to the language in EEOC's Management Directive 715. And it really lays out some structural requirements. It says that the model EEO program is not under the control either structurally, meaning organizationally, under the umbrella of general counsel or human capital, or practically. Sometimes it doesn't look like it because the structure may have some different variations, but really in order to do their work in the EEO program, they have to run it through OCHICO or through general counsel. And this is saying that that would be a violation of the statute to have it. And then it also requires that there be a real look at internal conflicts of interest that may impede the fair operations of the EEO program. So, where are the potential conflicts of interest where the EEO program may be compromising in neutrality, and making sure that the agencies have procedures in place to address those. And then the final subsection C says ensure the fair and efficient fair resolution of complaints. And so making sure that the complaint process is fair and operating in a neutral fashion. Now, one of the things that for those who work in the EEO area, that for years, we always talk about the role of EEO, the role of general counsel, because they both have roles in this process. The EEO office is supposed to be the independent, neutral office at the agency that is looking at complaints of discrimination, allegations of discrimination, and opportunity, and trying to find a path forward, whether that means doing an investigation and making a finding that, yes, this employee was discriminated against, and then helping the agency take action against anyone who's engaged in discrimination. And the general counsel's role is once, someone has started litigation against the agency, they have the role to defend the agency, and that creates some unique overlap in our process, because you have one part of the agency acting as an independent adjudicator of claims, and then you have another part of the office another part of the organization that's required to defend the agency. And it does create these issues of conflict within an organization. What this provision is saying, even though the Cummings Act is saying the general counsel should not have a role in overseeing the EEO office, it's also clarifying that the agency counsel still has a role to make sure that they're providing good advice and counsel to the agency. And a lot of times in our Management Directive 110, where we lay out the requirements of the complaint process, we say something very similar. The good agency counsels are great in terms of really helping the organization understand how to address discrimination. And there's going to be times where a management official or an employee may want to talk to someone in general counsel before going to EEO. And we're not saying they can't talk to them. We're just saying that they can't then dictate how the EEO process will flow thereafter. So agency counsel still has a valuable role in providing advice and counsel to members of their organization. In a similar vein, just to re-emphasize the importance of the EEO program, the statute also lays out that the head of the EEO program, and that means the person who manages the day-to-day EEO program, and I know we have so many variations of how agencies have their EEO program structured, but this is pretty clear in saying that the head of the agency the EEO program head, or whoever you call your EEO director, your civil rights director, your diversity and inclusion, or opportunity director, because agencies have different names for it. But the person who day-to-day manages the complaint process, your MD 715, your special emphasis programs and things like that that make up your EEO program, regardless of what you call it, needs to be a direct report of the agency head. And this is similar to EEOC regs, but this is this elevates it to a statutory requirement. Then, as we move down the process, we get into findings of discrimination. And like I said before, EEOC doesn't have authority to discipline those who may have engaged in a violation of our laws. We can make whole relief to the victim of discrimination. One of the things that this statute leverages is the relationship between EEOC and the Office of Special Counsel. The Office of Special Counsel is another independent agency that does have the authority to prosecute federal employees for violations of the law and engage in discipline. And we have a memorandum of understanding with the Office of Special Counsel, but what this statute did was to take that memorandum of understanding and make it law, that if there's a finding of discrimination and EEOC believes it's egregious, we can refer those cases to the Office of Special Counsel and for them to take action, appropriate action with respect to the conduct of the employee. Now, it kind of lays out, other things that we will make the referrals, Special Counsel will receive them, and they will make a decision as to whether or not they're going to pursue prosecution of the employee. But as a part of the no fear reporting requirements, EEOC now has to report the number of referrals we make every year to the Office of Special Counsel with a brief summary of each of those referrals, and we make that information public in our annual report. We do an annual report on the federal workforce that you can find on our website, and now this type of information on referrals for disciplinary action will be a part of those annual reports for the public to see. And then I think I covered B. And then finally, not the final, but one of the last slides that deals with the Office of Special Counsel. The Office of Special Counsel will notify EEOC and the federal agency when there's been a referral and it decides to pursue disciplinary action. So they'll let the EEOC know and let the federal agency know. And they will also report back at the federal agency then imposes disciplinary action on their employee. So this all will be a part of the reporting mechanism. The final provision says the special counsel approval, and that says the federal agency may not take disciplinary action against a federal employee for alleged acts of discrimination referred by the commission, except in accordance with. Once it's been referred to special counsel, they have to follow the rules in terms of taking disciplinary action. And I know I'm moving quick, but like I said, as we go to the Q&A, I'll go back to any slide, and maybe I'll just start at the first slide, and then Nitra will let me know if there were questions about the first slide. The last slide just deals with non-disclosure agreements. This has been a hot topic issue for years, especially after the Me Too movement, where people were coming forward, but they had signed these NDAs saying that they can't disclose. One thing that this act does is it says that it prohibits non-disclosure agreements that's going to restrict an employee from engaging in whistleblower activity. So, they may have been involved in a complaint of discrimination, and the agency says, we're going to resolve it, make this employee whole. As a part of that, the employee will not reveal terms of the settlement agreement. But since this is a form of government misconduct, if that employee wishes to raise this in terms of a whistleblower or reporting things that are continuously going on, the NDA is not going to preclude that employee from further whistleblowing activity. And so, like I said, that is the sum of the act with respect to what we do at EEOC. Now, I would encourage each of you to go out, get a copy of it, read the entire context of the act so that you can understand the scope and the things that affect Office of Special Counsel, the things that affect OPM. But in a nutshell, that is kind of the coverage issues. And remember, this is an amendment to an existing act, which is the No Fear Act, the Notification Federal Employee Anti-Discrimination and Retaliation Act, which also has its own provisions where annual reports are required. You're required to put data on your public website. All that is still in play. This is just on top of what's already required by the No Fear Act. And with that, I will turn it back to my colleague, Anitra.
I'd like to say thank you again on behalf of the Office of Federal Operations and the Education Consortium. We appreciate your participation, and we ask that you have a great day. Thank you so much, Dexter.
For all the folks that said hi to me, I don't want to start naming names. Thanks. I saw so many of my friends in the room, and thank you all. Thank you all for all the work that you do. None of the things that we do at EEOC or through this legislation could happen without the work that all of you do. So thank all of you, and thanks, Anitra, for really putting this together and creating this forum. I appreciate it.
You're welcome. Thank you. We greatly appreciate you being our guest. All right, everyone. Have a great day. Thank you again.